another against Swindon Borough Council.
This appeal is concerned with the purported imposition of in a planning permission by a planning authority of a planning condition to make the owner of land dedicate roads which it had constructed on its land in carrying out its development for public use as highways. The principal legal question is whether, as a matter of law, planning conditions can be used for this purpose. The factual background to this legal dispute is that the owners of a site immediately to the south of the A420 road on the eastern outskirts of Swindon sought planning permission for a mixed commercial development. The site was part of a wider land allocation which Swindon Borough Council, as the planning authority, had identified as the new eastern villages. This is a strategic allocation of land for economic and housing growth, which is planned to provide 8,000 homes and also employment land and retail, education and community uses. The development site with which this appeal is concerned borders the A420. The main access roads within the development site, that is both the north-south axis and the east-west axis, which the planning permission had authorised, were intended to provide access from the A420 to other sites within this wider New Eastern Villages development. The local authority had power to acquire the land on which the access roads were built by compulsory purchase under the relevant planning legislation and also under the Highways Act on payment of compensation to the site owner. Alternatively, the local authority could avoid paying such compensation if the site owner entered into a voluntary agreement with it to construct the access roads on its development site at its own expense and to dedicate those roads as public highways, thereby giving the public a right of access over those roads. The local authority did neither of these things. Symmetry Ltd, which I will call DBSL, purchased the development site from its owners, which had earlier obtained the planning permission. DBSL then applied for a certificate under Section 192 of the Town and Country Planning Act 1990 to confirm that the construction and use of the access roads as private roads would be lawful. By way of explanation, in doing so, DBSL envisaged that if, as it believed, it was not under an obligation to dedicate the access roads for public use, it could recoup some of the cost of constructing those roads from the owners of the development sites within the Eastern Villages land allocation in return for its granting a license to those owners for the public to use those roads or for the dedication of those roads as public highways. The local planning authority refused to grant the certificate which DBSL sought on the ground that the planning condition, a planning condition, obliged it to dedicate those access roads as public highways. DBSL appealed this decision to the Secretary of State, whose inspector granted its appeal. The local planning authority then sought a statutory review of the inspector's decision in the High Court, and the High Court judge disagreed with the inspector and allowed the review. DBSL then successfully appealed to the Court of Appeal. The local planning authority now appeals to this court. This court unanimously dismisses that appeal. The first issue which the court addresses is whether it is lawful for a planning authority in granting planning permission to impose a planning condition that the developer of land will dedicate land within its site as a public highway. The court holds that it is not lawful to do so. The statutory provisions concerning planning conditions, while broadly worded, must be interpreted in the context of the Planning Acts as a whole, including the provisions relating to compulsory purchase and planning obligations. Agreeing with the Court of Appeal, this court holds that the long-established decision of the Court of Appeal in Hall and Shoreham by Sea Urban District Council, which was decided in 1964, is authority for the legal proposition that a planning authority cannot impose such a condition on a landowner. It is long established that a planning condition must be imposed for a planning purpose and not for an ulterior one, that the condition must fairly and reasonably relate to the permitted development, and that it must not be so unreasonable that no reasonable authority would have imposed it. It is also government policy from the outset of the planning system that planning conditions cannot be imposed to require a landowner to cede land for road improvements. The court examines the law relating to planning obligations. The parties to the appeal are correct in their acknowledgement that the local planning authority could have achieved its wish and avoided the cost of compulsory acquisition if it had persuaded the landowner to enter into a planning obligation to dedicate the roads as public highways. Often, a developer of land does so as a means of obtaining a satisfactory planning permission, and such a developer may have limited scope to resist a request by a planning authority that it do so. But the court points out that there is a fundamental conceptual difference between a planning obligation to which a developer has to agree by its own voluntary act on the one hand, and a planning condition on the other, which the planning authority can impose unilaterally. The options open to the planning authority are therefore either to acquire the lands for public roads compulsorily on payment of compensation, or to persuade the developer to enter into the necessary planning obligation to dedicate the access roads as public highways. The second issue in this appeal is whether the planning condition which was imposed in this permission was properly interpreted, as the council submitted, as imposing an obligation to dedicate the access roads as public highway, or, as DBSL submitted, was directed to controlling the quality of the roads to be built and the timing of their construction. This court agrees with DBSL's interpretation. It explains, consistently with its earlier judgment in Trump International Golf Club Scotland Limited, that planning conditions are to be interpreted in a similar manner to other public documents, asking itself what a reasonable reader would understand the words to mean when reading the condition in the context of the other conditions and the planning consent as a whole. This is an objective exercise in which the court will have regard to the natural and ordinary meaning of the words, the overall purpose of the consent, any other conditions which cast light on the purpose of the relevant words, and common sense. In agreement with the Court of Appeal, this court explains in its judgment its interpretation of the relevant planning condition, which it holds to be valid, as it did not purport to require the landowner to dedicate the access roads as public highways. The court will now adjourn.